Good evening, everyone. I'm Aswini Weereratne. I'm currently the chair and head of chambers at Doughty Street. We have a large audience. We had a larger audience intended, but the weather has obviously intervened. But I welcome you all. I'm delighted to do so to our event, which aims at a candid appraisal of a force that's rapidly reshaping our profession. AI is no longer a futuristic concept. It's here in our homes and in our working lives, drafting contracts, making claims, reviewing disclosure, creating chronologies, predicting case outcomes, and a lot more. As lawyers, we have to keep up. Here at Doughty Street, we have been working at understanding its place in our practices for some time, but it's hard to be clear on whether this is a force for good or evil. AI brings the promise of remarkable efficiency. Tasks that once consumed hundreds of hours can now supposedly be handled in minutes. But what of accuracy and errors? AI can enhance access to justice by reducing costs and making legal services more affordable to underserved individuals and even small businesses. But is it true that bots and AI-powered legal assistants can help bridge the gap for those who cannot afford traditional counsel without compromising quality entirely? AI promises powerful insights. Can predictive analytics evaluate case histories, judicial behavior, and settlement trends to give lawyers a strategic edge? Imagine walking into a negotiation or even a courtroom already knowing with statistical backing the likely range of outcomes. That's likely to be a game changer currently being exploited to varying degrees of success in, for example, elite sports such as the Premier League football. But the disadvantages of AI could be substantial. There are ethical risks. AI systems are only as unbiased as the data that trains them. If historical data reflects bias, racial, gender-based, or socioeconomic, there are serious implications for predictions, analytical work, risk assessments, and so on. And who's responsible if the AI tool goes rogue, provides duff advice, or misinterprets the law? How will regulators respond? Are there risks to the profession itself? For juniors, associates, paralegals, if we erode the foundation of experiential learning, the future of the legal profession is surely threatened. Is this existential? Tonight, we'll be looking at AI from various angles, and we have divided the evening into two parts. In the first, you will hear about regulatory and legal practice issues. To start us off, I'm honored to introduce a world-leading expert on the governance of AI and joint head of our newly formed AI team, together with Graham, who's on the panel, with us here. So that's Firth-Butterfield, who's kindly sent us a pre-recorded message because she lives and works in the US, but is currently in Madrid and unfortunately cannot be with us in person. Kay is a barrister, a former judge, a professor, technologist, and entrepreneur with an abiding interest in how humanity can benefit from new tech, especially AI. She is a senior research fellow at the University of Texas and a fellow at New America in the Future of World and Innovation team. She's authored books on human rights, AI, and modern slavery. Then we'll hear from William Dunning of Simmons and Simmons. William is an expert in AI law and regulation, ranked as a leader in AI in the Legal 500. He is a supervising associate in the Disputes and Investigations team in London and routinely advises major corporations on global AI regulatory compliance affairs. Then we'll have Graham Denholm and Matt Lee, both barristers at Doughty Street. Graham is joint head of the AI team, as I mentioned a moment ago, with Firth-Butterfield. He specializes in civil and public law, and we'll discuss the scope for AI across different practice areas. Matt is a housing barrister and prolific blogger on AI. He authors the AI legal blog, Natural and Artificial Law. He will look at negligence and the use of AI and highlight some current cases in the news. We'll then pause for questions, which you will have some time for, good time for. And at part two, we'll look at the use of AI in legal practice more widely. We will hear from Tara Lynn Waters, a digital transformation consultant supporting law firms, businesses, and tech companies on the rollout of AI strategy, governance, and execution. Then we'll turn to Karen Silverman, CEO and founder of the Cantellus Group, advising boards and leadership at Fortune 50 companies and the public sector on strategies, risk management, and readiness for deploying AI and cutting-edge technologies successfully. Finally, we'll hear from our own Julie Ahadi, Director of Strategic Planning and Operations at Doughty Street, who will provide her insights into the work that we've been doing on AI here. And again, then you'll have another opportunity to ask more questions. So with that, I'm going to ask Ray to please play the recorded message from Kay Firth-Butterfield.
Good evening and welcome to this event at Doughty Street Chambers, our first event on AI and in my view, long awaited. And so I'm really sorry I can't be with you. I'm actually in Madrid, although I'm honoring one of our guest speakers who lives in San Francisco, Karen Silverman, who you'll be hearing from later. I'm Kay Firth-Butterfield. I'm an associate tenant of Doughty Street Chambers, and I've been working on the responsible design, development, and deployment of artificial intelligence since I became the world's first chief AI ethics officer back in 2014, before AI was known by most people, and certainly before the generative AI boom. I think we are seeing this more and more, of course, in our practices because you're using large language models, but also we're beginning to see cases where people have incorrectly used AI, something that I've been warning about for a long time. And of course, they have the effect of brand reputation risk and also can be quite costly. And I think that they're particularly interesting, even though obviously you're particularly interested in how you can make the most of it in your work. And one of the ways that I talk about that is really making sure that all of your employees understand AI, because once they understand AI, they can move from being frightened it's taking their jobs to finding a way of using it usefully and responsibly. And also you can, if you're training your employees, include that responsible AI use, which is becoming more and more important, as I'll talk about in a moment. My day-to-day work is actually helping organizations to design, develop, and deploy AI wisely. And what organization wouldn't want to deploy AI wisely? Really making sure that we're thinking about the possibilities of brand risk and the possibility of litigation, whilst also thinking about how you use AI successfully and beneficially for your company. And we are privileged to have on the panel Matt, who will be talking about using AI in your practices. And also we're going to talk about the European AI Act, which of course is so important for all companies and most of you who are actually working within the EU as well as in the UK or perhaps in the US. And that's completely different can of worms, and Karen will no doubt talk about that. And so I will be handing on to Graham, who is my co-lead of the AI group in Chambers shortly. But I just wanted to really talk a little bit about the developing cases that I'm seeing across the globe around misuse of artificial intelligence. So let's look at surveillance, for example. I think that any dictator, and we could go back to Hitler or we could look at some of the current dictators in our world, would be delighted to have AI as a tool. It is a fantastic surveillance tool. We can see it being used with facial recognition. The Israelis have created algorithms that can actually do partial facial recognition. So when you're thinking about the right to protest, how much of your face do you need to cover up? Now, probably all of it. We can think about drones for surveillance, and of course drones in warfare and as lethal autonomous weapons, but also we can think about drones, because they're very cheap, as ways of harassing maybe your ex, because you can use an autonomous drone to follow them around. We know that the Chinese have made great strides in gait recognition. So even if you've covered up your face and gone to a protest in a land where they don't allow protests, they can still work, the authorities can still work out who you are from the way that you walk. And then there's the AI-enabled devices that we invite into our homes. And one of the things I've been talking about for a long time is AI-enabled toys. When we invite those AI-enabled toys into our homes, do we actually look at the labels? Do we work out what data is going to go where? Over 95% of the toys actually come from China. And do we actually find out from the box, maybe, what they are going to be teaching our children? I've always said that if I was a dictator, having an AI-enabled toy, which taught children about my beliefs, would probably be a really good tool for ensuring my success. Then there's deep fakes, and we've already seen problems around the world, the obvious one being the case where the lady in Hong Kong cut a check for $12 million in an entirely fake video conference. So we're going to be seeing that, although recently, of course, we saw that at the Adobe BBC consortium that's been set up has actually been successful in helping us try to think about watermarking images to show origin, although that doesn't actually help us in video conferences. And then there's shadow AI. I think a lot of companies haven't really thought through process. And so therefore, they might not have thought through how to set up guardrails to really ensure that everybody is on the same page for using AI. And this is particularly true in smaller companies. So I had a recent example where I was approached by a smaller company, so not a Fortune 500 company, but a company that provided safety critical services. And one of their employees had used AI to help, had used a chatbot, an LLM, to calculate the size of a gauge. And when that system was put in place, and that gauge was asked to work, it blew up, because it wasn't the right size gauge, and it blew up, causing noxious chemicals to infect the site and the people who were nearby. So is this the problem of the company, or is this the problem of the employee who used the AI? We call it shadow AI because the company didn't know that the person was using it, but they were using it, and it did result in harm. So when we're thinking about helping smaller companies, one of the things that we can do is actually say to them, you need some rules. You need some rules to say, don't do this. Maybe a blanket rule which says, do not use your own version of X chatbot in the work that you do in our office. So lots to think about, lots to talk about, and I'd like to leave you with two thoughts. One is, in a world where everybody's using AI and everybody is superhuman, how do you think about new management and leadership practices? Who are you going to promote? And how are you going to manage a workforce that's human and AI, and just AI? And finally, you may all remember Tristan Harris and Asa Raskin and their film, The Social Dilemma. They said, when thinking about LLMs, that our first encounter with AI had been social media. What have we learned from our encounter with social media that makes us any better enabled to deal with our next encounter, i.e. with large language models? I'll leave you to think about that, and I hope that the evening is extraordinarily beneficial to you. Thank you.
Thank you very much. Thanks, Ray. So I'm just going to go straight through to Will. Thank you very much, Will.
Thanks. So I'm going to talk briefly about the EU AI Act. And the EU AI Act is probably the most advanced, at least in terms of timing, if not in terms necessarily of substance, of any attempt to regulate AI so far. The EU Act is a comprehensive regulatory framework for AI, and it is already largely in force. Yeah. So I think I've been given 7 minutes to summarize the 144 pages of the EU AI Act. And so I'm going to try and whiz through this quite quickly. Obviously, feel free to ask questions when we come back for the Q&A. So first starting point, the AI system is the fundamental regulatory unit that is regulated by the EU AI Act. That is what is regulated by it. What we are talking about there is input-output systems that use AI technologies, so machine learning, large language models, and create some kind of output from an input to influence some kind of environment, be it your computer screen or the robot or a robot arm in a factory. So ChatGPT, the web app you access, is an AI system. Equally, a tool for screening CVs might be an AI system, and a tool for controlling that robot arm may also be an AI system. Now, both the development and the use of these systems is regulated. That means that providers, that is people who make the AI systems, are regulated, and deployers, that is people putting them into use, are also regulated. I won't go into it now, but there is broad extraterritorial application. So while we have left the EU, we are not necessarily out of the woods on the EU AI Act. Now, how are these AI systems regulated? So the chief architecture of the AI Act is a risk-based approach to regulation. So at the top, if you imagine a risk pyramid, at the top layer of the pyramid, you have certain AI systems that are prohibited, that are banned outright in the EU. So this is AI systems that deploy subliminal, manipulative, or deceptive techniques, or that exploit people's vulnerabilities due to age or disability. They also, picking up on a topic Kay was talking about, cover some systems for surveillance. So remote biometric identification systems, which can only be used in very limited circumstances, or tools for gathering facial images from the internet for the purpose of identification. That's the top of the risk pyramid. Some things banned, fines of up to 7% of turnover for any breach of those prohibitions. Moving down, you have really where the meat of the EU AI Act is, and this is high-risk AI systems. So these are the best comparable bit of regulation out there is probably something like the medical device regulation or the regulations that affect cars. So what is happening is these AI systems are being put on the same kind of footing as a car or a medical device. They're going to be highly regulated. Now, this covers very specific types of AI systems. So this is AI systems for things like human resources. So that CV screening tool we touched on might be a high-risk system. There are some limited legal services AI systems that might be caught here, but they are chiefly ones that are going to be used by judges or by, say, arbitrators rather than by private practice lawyers. Now, if you've got a high-risk AI system, the short version is it's going to be very heavily regulated. There are requirements about the training data that you can use. There are requirements about how you're going to assess and mitigate risks, how you're going to monitor it once it's on the market, heavily regulated. Now, then you move on to the bottom of the risk pyramid. So this is other AI systems, and this is probably where most AI actually lives. And those AI systems are only subject to quite limited transparency requirements. So think, if it's a chatbot, it should be telling people that it is an AI. It shouldn't be essentially deceiving them into thinking that they are speaking to an actual person. If it is generating synthetic content, so synthetic images or video, there should be labeling to say this was generated by an AI. So that's the very, very quick version of how AI systems are regulated under the EU Act. Now, that is the risk-based approach, and that's how the AI Act started. Halfway through the development of the Act, though, you got ChatGPT come out. And this is obviously very different to all the technologies that came before. And that led them to add an extra layer of this, a sort of technology-based bit of regulation for general purpose AI models. And this is basically targeted at tools like ChatGPT or the models that underlie it, and impose another whole layer of regulation for those particular tools. I won't go into detail on what is required there. It's mainly about transparency and copyright and assessing and mitigating risks. Now, I mentioned a lot of this is already in force. So timeline, first provisions came in earlier this year. The key date really is August next year, when all of this architecture is really going to be in force with a few little carve-outs. Now, that's a very, very quick version of the EU AI Act. I think it's worth just very briefly touching on how this links up to approaches in other jurisdictions. Because as I said, you've really got a mix of approaches here. You've got this risk-based element, different risk tiers, and you've also got a technology-based element. And what we're seeing elsewhere is there's not so far been a big Brussels effect where every other country is barreling down the same route as the EU. In fact, what you're seeing is different approaches being taken in different places. So in Colorado in the US, for example, you have something very similar to the high-risk provisions under the EU Act. In the Labour manifesto in the UK, it sounded like we're going to get something very similar to the general purpose air models. That seems to really have been shelved at this point. There are also obviously other approaches that you may have to regulating AI. So the private members bill outstanding in the UK at the moment is a sort of principles-based approach. It's not sort of a product safety piece of legislation. I've probably talked too long at this point. So I'll hand over to Graham.
Thank you very much, Will. Fascinating. Thank you. So I'm going to touch very briefly on how AI is likely to feature as the subject matter of the sort of litigation that Doughty Street does and the sort of litigation that our clients do. And we're thrilled to have people here this evening who've got a background in the corporate world, but we tend to inhabit a world of acting more for individual clients than large organizations. We tend to act for a client base of small to medium-sized solicitors. And the sort of understanding and adoption of AI, I think, both amongst barristers working in the sort of areas that we do and amongst our client base, is probably less evolved and less consistent than we're seeing in the corporate space at the moment. And a lot of the work on the sort of right side of EI seems to be taking place in the policy sphere rather than the legal practice sphere at the moment. But I think that's going to change, and I suspect it's going to change fairly rapidly. So I want to look at how it's going to impact work in sort of looking very broadly at the sort of work we do, looking at the kind of private law work we do, the public law work that we do, and the criminal work that we do. And as a broad kind of theme, I think we're going to see cases that relate both to direct harms that result from AI use, and we're going to also see more sort of challenges to more systemic issues about AI deployment. As was implicit in what Will was saying, as things stand, there is no specific regulation of AI in legislative regulation of AI in the UK as at present. So deployment of AI in the UK is governed by existing legal frameworks, areas like the GDPR governing data protection law, the existing criminal law, existing tort law, and so forth. And it's those long-standing legal principles at the moment that have to be adapted to work within the context of these evolving technologies. So looking first at the private law sphere, I thought it might be interesting to give an example of a case that's taking place in the US at the moment. The case is called Megan Garcia versus Character AI. Now, Megan Garcia is the mother of a young man who took his own life after engaging with a chatbot that was created by the Character AI app. Character AI being an app that allows people to interact with characters that they create using the app or that other people have created. In this case, the character was a character from the TV series Game of Thrones. This young man became increasingly involved with this chatbot, interacting with it for long periods of time. Conversations became increasingly dark, turned towards suicide. There was discussion of suicide. And then, as the New York Times reported it, on the night of the 28th of February last year, in the bathroom of his mother's house, the boy told the chatbot that he loved her and he would come home to her. "Please come home to me as soon as possible, my love," the chatbot replied. "What if I told you I could come home right now?" the boy said. "Please do, my sweet king," the chatbot replied. And that's the point at which this young man took his own life. That litigation is live in the US. His mother is bringing an action in product liability, in negligence, and alleging unjust enrichment amongst various other causes of action. It's attracted quite a lot of attention for various reasons. One of the areas where it's attracted particular attention is the fact that the AI company is relying on the free speech rights of the chatbot as a defense to the conduct of its product. In the allegation is leading this young man to take his own life. I'd suggest it's immediately apparent that if we look at the sort of work that we do across chambers and across the sorts of firms that instruct chambers, this is going to, and I think one of the interesting areas is how multidisciplinary this work is going to be as it emerges. I think this is going to touch a case of that nature, would touch on coronial law, the inquest side of things. It would touch potentially on negligence, product liability, human rights issues, the regulatory framework for companies like this, and so forth. But I think that's very much the sort of litigation that our instructing solicitor base is likely to be interested in pursuing, and it's one amongst many examples of AI harm. Turning to the public law sphere, there's a sort of three broader points about the deployment of about AI systems and their use in automated decision making. The first is a lack of accountability in decision making by machines. The second is the risk of inbuilt bias, that as Aswini and I think Kay as well mentioned, that the outputs from the systems depend on the data that they're trained on. And if there are biases in the training data, those biases are reflected in the outputs from the system. And the third is the risk of mistakes. Now, one thing that we see at the moment right across the public sector is a huge, huge amount of pressure to save time and to save money. There isn't a government department that doesn't have the minister leaning on them to cut budgets left, right, and centre. And the temptation to shift decision-making into automated systems, I think can't be overstated. I do quite a lot of work in the immigration space, and the Home Office just about 2 weeks ago published the outcome of trials on the use of AI in the asylum determination process. So using AI to summarize interview transcripts and using AI to give guidance on information about countries of origin. But you see this across the public sector. The Public Law Project, which is an NGO and law firm that works on public interest litigation in the public sector, has a database of public decision-making algorithms. And I think the last time it was updated, it was up to 55 different examples. And then, conscious of time, I'm just going to touch very briefly on the third area, criminal justice. And we're going to see, I think, in the criminal space, a great deal of use of AI as a tool, but that brings with it substantive issues. One of the areas where it's been flagged is the use of AI as a disclosure tool, particularly in large-scale fraud litigation, where multiple cases have collapsed because of faulty disclosure in the past. So the success or failure of those AI systems in giving proper disclosure is going to be central to whether those prosecutions can run the course. And if there are flaws in the electronic disclosure process, then that is going to substantively impact the case. It's not just going to be a practice question. There are going to be issues around the reliability of digital evidence. There are going to be need for perspective on new experts who can deal with all of this. There are going to be, as people have touched on, deep fakes, artificial image abuse, exponentially stronger tools for committing fraud, voice cloning fraud, and so forth. And I could speak on all the other areas that we do in chambers. There isn't an area that's going to be unimpacted, but I'll leave it there, and perhaps we can come back to those other areas in the Q&A.
Fabulous, thanks. Graham, I'm going to ask you please to speak into one of those microphones so that we can be confident that everyone is hearing everything, and also put your voice up. Thanks. Thank you.
Okay, thank you, Graham. I'm discussing something slightly different. I don't know if anyone's seen my blog. I'm not trying to advertise it, of course. I'd hate for all of you to subscribe and read it. But when I started the project, what I was doing was I was collecting lots of different decisions across all jurisdictions about how judges were talking about AI. And as sad as that sounds, it actually became quite interesting. And as I started to produce on my blog the different decisions and explain how people are dealing with these things that come up, and it comes up all the time. So we have it in almost every aspect of the courtroom. We have it in submissions. AI is used for that. The judges are now using AI. We have AI witnesses. We have AI experts. And the courts are really grappling with how they're going to take this information in, whether it should be admissible, and if so, what are the rules? And we're really starting to see this building of case law and interesting ideas. But each jurisdiction is very different with how it's dealing with it. And when I was trying to work out what to talk about, I had a look at the statistics on the blog, and by far the most viewed or most the point of most interest to people was AI hallucinations and how they're featuring in response to professional responsibilities and obligations. And so that's what I'm going to focus on. And it starts really with a quote from Sir Geoffrey Voss, the master of the rolls. And when he was speaking in February 2025 at the LawTech UK Generative AI event, he said this: "One of the biggest fields of legal activity in years to come is likely to be claims that will be brought in respect of negligent or inappropriate use of AI, and also negligent or inappropriate failure to use AI." So we know the first one, we hear about it a lot, where's AI being misused, but is there also negligence claims where someone has failed to use AI and they really should have? And there's some really interesting discussions about this, but this really is an emerging area of law. I don't know anyone in any of my instructing solicitors who currently say expressly, I practice in AI negligence. But if this is going to be one of the biggest areas of law, it's something we should really be thinking about. And it is so broad. But what I'm going to focus on is the hallucinations and professional negligence element, because we now have some case law and something to seriously talk about. So for those who don't know what AI hallucinations are, it's a bit of a slang term. And the way I'll describe it is by giving you a practical example. When I was preparing to speak to everyone today, I used my deep research AI tools to look up some statistics for me. I wanted to know exactly how prevalent checking of legal documents was. And what happened was I got a return and it said this: 40% of legal professionals admit to not double checking AI outputs before use. And then it said this is found on the Bar Council briefing meeting, March 2025. I thought, my goodness, that's remarkable. So I went online and looked for it, and guess what? Doesn't exist. Completely made up. Because what my AI tool was doing is it knew I wanted a statistic, it knew I wanted to present it. So instead of giving me something real, it just made it up. And so I've now checked that's not true. And I mean, can you imagine that sort of invasion? As a practical tip, if you see something that's just incredible or too perfect for what you're trying to present, it probably isn't right. So please take extra care. So if you follow AI hallucinations, and in this context, I'm talking about it where lawyers, I'm not talking about litigants in person, lawyers are using completely fabricated cases with fake, or not just the case is wrong, but the principle is wrong. And sometimes the principle isn't wrong, but the case is wrong. And sometimes the principle's right and the case is wrong. And you end up in this situation where everyone's utterly confused. And you'd think this would be something happening just with litigants in person, but it isn't. Across all jurisdictions, lawyers are presenting these documents to the court. And I'll just go through some of the main examples so you can see where it's happening. The first famous one is a US case called Matter and Avianca. And in this case, and this was June 23, so you can imagine there is probably not as much broad knowledge about LLMs and how they're used. The lawyer said he just couldn't believe that the case was fabricated. The cases he presented to the court, he said he was not even looking for it because he didn't think it was something that was possible. In the UK, we had a case called Harbour and HMRC, which was widely reported in 2023 as well. And in that case, the UK tribunal took the Matter principles in and adopted them, where similarly fake cases have been presented to the court. And they said there's 4 real problems with presenting fake cases to the court. First is it wastes time, extreme amount of lawyers and judges' time in trying to work out what's real and what isn't. Secondly, it means people don't get the benefit of cases which may well help them because they're too focused on these fake cases. Thirdly, it causes reputational damage to the individuals involved. And fourthly, it promotes cynicism amongst the public about whether they can trust legal professionals of the judicial system. The next case of note is a Canadian case, Zhang and Shen, and that's from 2024. And there a lawyer included 2 non-existent cases, and this was in a family application. And when questioned, the lawyer said she admitted that she was not aware that AI was capable of generating fictitious authorities. The judge said, the judge found the failure was to heed the express warning on ChatGPT website that the output could be inaccurate and that using ChatGPT was not a substitute for professional advice. And I just pause in there. This does One concern I have, and those of you that use ChatGPT will know this, even though it does say that, if you ask it for legal advice, it's quite capable of giving it to you and acting very authoritative when it does that. So for us, we might be able to read and understand the disclaimers, but for litigants in person, how are they to know? If you say, please help me with this, it will jump on and help you. And so I'm not convinced that just because that warning's there, that's enough. I think there should be more done to be clear about what's being generated. Now, last week we had a very interesting decision, and you may have seen it because it was widely spread. It was Ayinde and Haringey 2025, and this was in the High Court. And I'm not going to go into the facts because as a housing barrister, I find them very interesting because in essence, it's a local authority who didn't do anything they were supposed to do. They didn't file the acknowledgement of service, didn't do a defence, didn't do a skeleton. And the case was extremely strong from a housing point of view. And one would have thought that that would be enough. It was so strong that the case would finish. The problem was the other side made an application for wasted costs against the lawyers involved. So the hearing had to go ahead to decide that also. And the reason an application for wasted costs was made is because there were 5 fake cases that were hallucinated. Now, I've read the decision and I find I'm not quite, I think there's a lot missing from factually why it went that way. But certainly there were significant problems with the citing of the fake cases, but even more so, the doubling down and trying to find excuses. Mr. Justice Ritchie was not happy at all and did make the wasted cost order against the lawyers. Now, what's important for us and for these purposes, and the reason I bring it up in terms of AI negligence is this. There was a comment made, which I think is of broader public importance and for us all to think about, and it's this. And I should be clear, first of all, the judge did not find that the barrister had used AI. He said he wasn't going to determine it because the barrister had not been cross-examined on the issue. But he made this comment. I consider that it would have been negligent for this barrister, if she used AI and did not check it, to put that text in her pleading. Now, this is the first time I've seen in any jurisdiction a very clear comment about what would amount to negligence. And it seems to be this. Now, for those of you who are solicitors and thinking, well, my barrister better be very careful then. He went further. He said, I should say it is the responsibility of the legal team, including solicitors, to see that the statements of facts and grounds are correct. So both barristers and solicitors have a responsibility to make sure that this doesn't happen. And if we don't, it seems that there's going to be some significant problems and allegations of negligence in the professional setting. Now, I have several concerns about this. One of them is when do we get to the point where we have to accuse our opponent or bring it to the court's attention? Is there certain things that are maybe more permissible and others that really need to be addressed? And there's so many questions about how we're going to do that. Because what we don't want to do is we don't want to make allegations that don't really have the base. Because, for example, those of us that use generative AI may see something that looks very much like it was generated by AI, but it isn't. And then a lot of the court's time and resources is put into trying to determine that issue. So we want to make sure that we're keeping our professional obligations at the forefront, but at the same time, not wasting the court's time or even accidentally misleading the court by making allegations that are not founded. So just finally, this is an extremely important and upcoming area of law. I think we're going to see a lot of litigations here. And I just want to give some potential, 5 potential ways we can try and avoid this in legal practice to avoid any kind of hallucinations. Firstly, it's obvious, always be careful with AI and assume that it's not going to give you correct information first off. My view is if you treat it like a trainee, someone who's trying to understand and grapple with the law, give it that sort of attention, look and make sure that you have properly checked every source and what's said. Secondly, I would put in place verification procedures and policies. So policies within firms about how you're going to check and set aside time for that, and which, if you're going to use AI, which models you think are going to assist with this. Thirdly, when meeting deadlines, I would suggest that you give enough time for a check of everything that's in the produced document. So if you know the deadlines at the end of the month, make sure you have it ready in good time so those checks can be carried out. Fourthly, learn to use AI tools, learn to spot when they're being used, and don't be confused about whether or not they're there. If we don't get to grips with these tools and what they look like, we may well miss when they're being used and may well not be able to make allegations we should have made, and make sure that we know everything we're saying. And then finally, then this one is something that we're going to have to think about more. When I discuss this with machine scientists, their solution often involves using AI to check AI. And I would urge extreme caution with that. If you have AI checking AI and there's two hallucinations, I don't know where it stops. It's turtles all the way down, isn't it? AI to check the AI, to check the AI. So just have human oversight at all times. Those would be my 5 points. Thank you.
Thank you very, very much. Thank you, Matt. So now we've come to the end of the first part, as I described earlier, and we've got about 15 minutes or so to have some questions. So what we heard, obviously, very interestingly from Will about EU regulatory frameworks and about the lack of a specific legislative framework in the UK. Graham gave us some teasers around what our practice areas might, how they might benefit and where the pitfalls might be in using AI. And of course, we've had some very useful tips from Matt in relation to if you are going to use it. I have to say a number of burning questions of my own, but before I do that, I think we'll look first to people in the room because I can't still see the people on the screen. I don't know whether that can be changed so I can see who they are. No? Okay. So this lady here, you're right here. I shall. You can ask the first question. Do you want to just introduce yourself, give your name and who you are, and then ask your question?
Hi, I'm Ornina. I'm from Wilson Solicitors. I'm a solicitor, public law solicitor. Really, I wanted to ask Matt, you said one of the tips is learn to spot the AI tools. Where do I even begin with that? And when I'm looking at just the documents.
So the problem is, and I'm going to have to concede this, I've been using AI tools for a long time, and what it does now is not what it was doing in 2023. That's one of the biggest problems. If you asked me in 2023, I could have given you a very clear list. It's looking for American spellings. It's looking for what's called the M-dash. I don't know if anyone knows what the M-dash is, you know what I'm talking about? Yeah. So the M-dash is this dash that goes like this. And for those of you on LinkedIn, a little tip, if you see these long comments, there's loads of M-dashes, and they're different from normal dashes. They're not, sorry, again, slightly technical, they're not little, they're quite long. It may have been used there. That's one of the key telltales. But the problem is they're getting so good and they're constantly being trained that what you see now can be prompted in a way that it's extremely difficult to know if it was generated. But if you are using the tools regularly, you can see the language. And unfortunately, it's going to become more difficult to spot it. But if there is a serious concern or something about it, so as I said, one of the things to look for is whether an authority is cited, which just is almost too good to be true. Make sure we check that. But in the public law, sorry, do you work in, tell me about your public law practice, is it?
Majority against the Home Office. Yes, false detention claims, a bit of asylum accommodation issues, things like that.
Yeah, so with that, what I find interesting, and I'm going slightly off topic, and I know it's not exactly what you asked, but hopefully you'll find it helpful, is that they are, as Graham pointed out, there's mass adoption of AI tools in the public sphere. But what I'm concerned, and I'm not making any allegations at the moment, but what I'm concerned about is that they do not have the necessary policies and procedures to bring them in. And we need to, there's two things that are important to look for when you see this content. The first thing is advice. I'd suggest that when you see a decision made by a public body, you ask whether AI was used. And if they say it was, then the next question is going to be policies and procedures. Which one did you use? And this is the most important thing. What prompts did you use? If you get a prompt back, which is something along the lines of make the decision for me, or I want to find this person, enter bad decision, help me do it, then in public law, we've got a knockout claim. But unfortunately, I can't, even if I was to give you what I think today is a very good way of spotting generated content, next week, yes, next week it could be better. And universities are finding this impossible to follow.
Thanks. Anyone else in the room? This gentleman here.
Thank you. I'm Debish Day from Landmark Law Solicitors. I specialise in criminal defence. What I wanted to ask, I think it's Will, is whether there is any moves towards setting up an accreditation body in the UK that AI tools can sign up to say that there is a minimum degree of trust that you can place because we are.
I mean, there may be some private efforts, but in terms of anything backed by legislation, there's nothing in the UK at the moment. I think the EU is going to have that. You know, the CE mark you see on toys and cars and so on is going to start. I don't know quite how it's going to appear on AI systems, but it's meant to start appearing on AI systems. I think we're a long way off that in the UK at the moment.
Okay. I think I might just, for the sake of fairness, see whether we can take a question online. Is there someone who'd like to ask a question online,
Yeah,
please?
so Hannah's got a question for you, Will, saying, I have a question about the EU AI Act. It was mentioned that we are not really out of the woods with it. What does that mean? Are there elements that may be binding? If so, in what sort of circumstances?
So it is genuinely quite vague. So the Act applies to people developing AI systems that are put in place in the EU. So if you're in the UK and you develop an AI system that's put in place in the EU, then you are caught. It applies to people deploying AI systems in the EU. So if you use an AI system in some way that touches that is in the EU, then you might be caught. Where it really gets vague is this reference to where the output of an AI system is used in the EU, then that AI system is in scope. So in principle, if you use an AI tool in the UK and you email the results to someone in the EU, that could be in scope of the EU AI Act. I mean, I have no idea how they think they might ever be able to enforce that level, but it does suggest quite a high level of extraterritoriality.
Thank you. A question for Graham from Joe Summers, from a research fellow at the Public Law Project. Given that there have been surprisingly few cases challenging automated decision-making systems in the public law context, what do you see as the key barriers to litigating automated decisions?
I mean, there have been a few cases. There was a judicial review claim against the Home Office in relation to automated decision-making around, I think, entry clearance applications brought by JCWI 4 or 5 years ago. I think I'm right in saying maybe not quite so long ago. And there was the case, the name of which I have written down, sorry, Bridges and the Chief Constable of South Wales about facial recognition, the use of facial recognition technology by the police in which was being trialled by a police force in South Wales, where I think it was Liberty brought a test case and was successful in the Court of Appeal. But I mean, I think if you look at who the claimants were represented by in those cases, it's quite a strong pointer as to why there are such hurdles to doing this. You know, in one case it was Liberty, in the other case it was JCWI, who are also a campaigning body that also do some litigation casework. These are cases that are going to be very complex and costly to bring. They're cases that are going to raise issues that are often, in order to address them properly, you have to address them on a systemic level, and sort of drawing out a case that sufficiently raises all of the systemic issues from the facts of a single claimant's claim can be incredibly difficult. And a great advantage that public authority litigants have is that they can settle cases out when they don't want the case to go all the way to trial. They can, if it's a judicial review claim, they can simply withdraw the decision that's under challenge, and the case necessarily falls away unless the court can be persuaded to entertain it as an academic challenge, which it very rarely can. So I suspect it's that combination of factors. It's the scale, it's the difficulty in finding individual claimants whose cases raise the issues with sufficient breadth that the whole issue can be litigated, and it's having sufficiently motivated and expert representatives to pursue the points. I think as these issues become, as the deployment of these tools becomes more widespread, we're probably going to see more litigation, but the hurdles are not going to get any easier to surmount. So the challenges will remain.
Yes, it sounds as if it's something that we're going to have to learn about as we go along, and it's going to keep changing. So we've got to be on our mettle, but actually challenging a government decision, if the government are using AI models to make their decisions, it's going to take some fairly astute work and persistent work to unpick it.
Yeah. And I think that, as Matt was saying, as the technology evolves and the issues become ever more complex, there's going to be a huge demand for expert technical input into these cases, as well as expert legal input, which is going to raise the barrier to pursuing it still higher.
Sorry, I'm just going to ask you a question in the sense that, so obviously we're looking there at the disadvantages, if you like, for from a claimant's perspective.
Yeah.
In relation to the use of AI, but just thinking about what Matt was saying around how we as practitioners use it in our day-to-day work, and you say you use it now. I would really hope that no one's using ChatGPT to draft pleadings or anything of that kind. And so we know that there are specialist AI packages that at the moment quite expensive, and that certain firms have developed their own AI within their firm, so that for their own work they can do that. So you can see that there might be safeguards around that, the use of that. But how do we, how do we navigate that minefield, if you like?
There's a few problems with that. Firstly, unfortunately, if I was to guess, I'd say people are using ChatGPT. The biggest problem with that is the confidential information that goes into it. So if ChatGPT is used to analyze public documents like, statutes and cases that are publicly available, I don't see a problem with that. It can be quite helpful. When it comes to private client data, I wouldn't put it near ChatGPT or anything like that. The problem we have as practitioners, and I think this will be touched on hopefully a little bit later, is that some of those products, not all of them, some of them are built on top of ChatGPT. So it's about understanding the product, what it's built on, and what protections are in place. And different products have different things in place, and I've heard good things about some of them.
Okay. All right. So we're going to hear some more. So let's get another question from the floor. I can't see who had their hand up. Could you just, right.
If somebody from a public body is relying upon a AI chatbot to come to a decision, aren't they unlawfully fettering their discretion?
Quite possibly, yeah. I think if they're literally relying on it, if they're saying, as Matt said, if the question that they're asking the AI tool is make this decision for me, then clearly they are, yes. If they, in terms of what the Home Office were doing with this trial of AI tools in the context of asylum decision making, the question there seems more nuanced, because they were using AI tools at two of the absolutely critical stages in the decision making process. One of them was the asylum interview, which is the key evidence base for making a decision. And the other one was the database of country information that was then applied to what's said in the asylum interview. And if the asylum interview is summarized by an AI tool before the decision maker reviews it, and the decision maker is considering it in the context of evidence about the country of origin that has been pre-selected by an AI tool, then even if it's the decision maker who's still, in a non-automated way making the ultimate decision, they've been steered in a certain direction by the tool. So there may well be arguments around fettering of discretion.
And then how do we scrutinize it?
Who's scrutinizing?
How do we scrutinize that?
Well, that's the critical question. Yeah.
It's also there's more public law issues as well. So this is why I was talking about policies. You've got to check that. So for example, if they adopt a policy that says we have an internal large language model and you must use that, but the person's gone and used ChatGPT, that's also moving outside the policies. That's another public law challenge. You've got to look at whether the models have inherent bias and discrimination. It's another challenge. And then whether they're honest about using it, good faith. There are so many public law challenges that I can envisage. The important thing is disclosure. And I can say it again, it's getting the prompts. What are they saying to these models? What are they asking for? It's going to be slightly more problematic when the decision is made by a person, but the LLM is used to almost justify the decision, because then you have to really look at what's happened there. This is an extremely in my view, an extremely important and upcoming area of law that all of us are going to have to deal with, all of us that deal with public law. And it's fascinating. But one of my biggest concerns, and I think Graham said it, and I'll just add to it again, is the speed of which this is happening. So if we started an action together today, how long would it take to get to final judicial review? By that time, would the tools have developed to the point of something different where it's almost academic? That's one of my biggest concerns with this, is how fast the technology is developing, and can we keep pace? And is the law able to? It's responding, and it needs to be proactive.
Julie, are there any more questions online?
There are quite a few.
So can we take a couple more, and then we'll go back to our speakers, and then we'll come back and take some more of those questions.
Yeah, okay. And some
as
of
we
them are
can.
more pertinent for the second section, actually, so I'll keep them
Yeah.
on ice. But Yasmin Adib asks, do you think there will be far more litigation against companies on privacy usage, especially if using AI, thinking about companies such as fashion brands, for example?
I think that short answer, yes. I think privacy legislation, I mean, obviously, most decisions that an AI takes that affect an individual will in some way involve their personal data. So you've got the GDPR applying there. You know, that bans solely automated decision making, which is obviously highly relevant to any use of AI to make decisions about individuals that does not have human oversight, which I think we've come back to again and again as really just a key ingredient there. And I mean, going back again to the EU, where there's already been one class action launched against, I think it was TikTok, under the EU AI Act. They brought that jointly under the EU AI Act and the GDPR, which of course still applies in the UK. So there's definitely scope.
Okay. Before we do another question, we're just going to come to the time, I think, where we should move on. I'm just going to ask whether either Tara or whether any of the other panelists have anything they want to say in relation to what's already been asked. Karen, no, nothing. Okay. Shall we just move on then? Let's move on to the second part, and we're going to start with Tara, if you're ready.
Yes. Hi, everyone. So I'm here to give you a little bit of the corporate law perspective from hopefully a very practical point of view. So hold my feet to the fire on that. So I guess if you were to read the headlines, all the articles, the news, etc., there's about a bazillion reports that have been issued in the past few months around AI adoption within the legal industry. I think you'd have the impression that the entire industry is racing ahead. We have broadly adopted AI. The AI robot lawyers are, just tapping us on the shoulder saying, get out of my way. I'm here to tell you, from my perspective, I think there really could be nothing far from the truth. I think in classic legal industry fashion, we are taking a very cautious approach. But what we have done, I think, which is very different from, for example, the cloud kind of evolution, which took about a decade for law firms and legal practitioners to get comfortable with using cloud, especially with clients and convincing clients that cloud could be safely used. I think we've slightly switched. In particular, a lot of the firms have been a bit more bolshy and said, listen, we're using AI, AI is here. We know you might have some questions and concerns, let's talk them through, but we're not going to wait and ask you for permission every single time you want to do it. We're actually going to start to be a bit bolder about that approach. Nonetheless, what I don't think is happening is widespread use of AI across all legal work types, all legal workflows, or up and down throughout legal organizations, or in-house teams, or amongst private practitioners. What we have seen over the past 2.5 years is probably a lot of people wanting to show that they're doing something, saying, okay, we are taking this opportunity, we recognize it as an opportunity. So we're seeing absolutely onboarding of tools, in particular legal specific tools, but actually, according to the reports that I've read, Copilot is still probably the most widely adopted, officially adopted tool or onboarded tool within the legal industry. So not everyone's rushing into the legal specific tools yet. Those firms, companies, practices that have some investment pots have been able to start to onboard legal specific tools. And what we've seen over the past probably 18 months is an insane proliferation of available tools. So I think whereas at the point of the A&O article in the FT that really kind of signaled legal is thinking about adopting AI or already in train. There were probably about maybe a dozen tools that you might point to, and some of them were kind of old AI pretending to be new AI. Whereas I think Legal Technology Hub, which is an online resource and service provider to the legal industry, now says there's probably over 400 to 500 possible platforms, all targeting different areas. So what we have is a number of what we refer to as horizontal platforms, generalist legal AI assistants. These are things that will, in most cases, have at a minimum something like a legal version of a chat GPT. So it's a chat bot that you can upload documents to, ask questions, and interact in a slightly more safe environment. And then they're starting to roll out different specific features in those platforms that will let you, for example, upload 100 documents or 1,000 documents and start to do things at slightly more scale and that start to replicate existing legal workflows. And I think ultimately what we're seeing in terms of the tools and the type of things that lawyers are actually using AI with a bit more regularity on is the types of things that we thought old AI was going to do well, but didn't quite do it. So, a decade ago, machine learning based AI, deep learning based AI started to enter in the profession. Actually, to be honest, e-discovery tools, which was machine learning and deep learning, has existed for 2 decades at least. So those types of activities, going through large volumes of documents, tagging them, classifying them, grouping them, identifying specific information in them and extracting that data out. That's stuff that we've been doing in legal industry for 10 to 20 years probably. What we're seeing now is the AI tools that are LLM based can do those activities almost as well, if not in some cases better, but then they can do more. So what we're seeing really with the shift of large language-based tools is not just the data identification, data classification, data extraction, but the ability to shift into other basically underlying activities or tasks. So things like just getting to the answer, asking a question of a document or multiple documents and getting to the answer. And that answer may not be pinpointing a specific piece of information. The answer may be actually trying to contextually understand various parts of a document or multiple documents to get to that answer. There's also things that it can do around summarization, because ultimately the generative part of Gen AI is the new feature, is the fact that it can create wholly new content. So the ability to take a 100-page contract and summarize that into 5 paragraphs of the key points. Those are things that the LLMs can do that the older AI was not something that it could do well. So I think ultimately what we're seeing is AI being shifted into more different tasks that can help and be done, that can help lawyers to do their work more time and cost efficiently. That is not a new concept. That's what we've been trying to get the machine learning and deep learning based AI to do for the past 20 years. So what we're seeing is it's just doing that, all the things we expect it to do, but then we're able to add more tasks to the list of things it can help us in terms of efficiency. But net overall, most lawyers are not changing the way they work. So we're using AI to do what we already do and do slices of what we do in a slightly more automated or efficient way. And that's kind of where we're at in terms of what are really people using it for. It's to find slices of time, to get back slices of time throughout your day doing the things that you normally do, which is great. And I've done multiple exercises now in multiple law firms where I can measure that value. I can tell you what that efficiency might look like. I can convert that into what a revenue opportunity or a cost savings opportunity that might look like. But the reality is, until you actually have large scale adoption, i.e. people using it every day, just as part of their workflow, always using it every time for that type of task, you're not actually getting the wholesale benefits that everyone thinks people are getting. So I think the firms and the people, and in particular, the firms and the practitioners who don't have big investment pots and feel like they might be getting left behind. I don't think we're in that place yet, but certainly having access to these tools will accelerate the ability to get to the higher value that there is to be had from LLMs. Are any current firms and kind of corporate practitioners that I know of really getting to that value? I think really only in very niche ways, kind of on the spectrum of adoption. I think only the people that are kind of at the far end. So, and I'll say, you know, if you take a firm like Baker McKenzie, they have a long history of having machine learning practice. They have been building their own specific AI tools, not just generative AI, but machine learning based tools. So for example, when they have a client that has a huge data breach, they can actually spin up a single point solution immediately because they have that tech team. And they can deliver a solution and work with them throughout the whole life cycle of that matter in a completely technology enabled way. We don't see a lot of firms with that capability yet, in part because very few firms have internal tech teams and that internal capability. Very few firms want to invest in that. But the interesting, I think, evolution that's happened, again, with the large language models is we are seeing more firms being willing to look at that build option versus the buy option. So I think in the traditional legal technology sense, buy has been the predominant strategy. And I think if you follow the headlines, some of the big law firms have either hired in or acquired or have decided to create from the ground up their own development teams to build something themselves. But I think importantly, to Matt's point, they're not building these foundational models because they do not have the money or resources to do that. So all of this technology is built and based upon the same group of underlying foundational models, which are created by one of Anthropic, OpenAI, R3, which is the Chinese company, Google, Facebook, et cetera, Meta, et cetera. So the underlying models themselves are all the same. At most, you might find, and again, this I would probably say you probably couldn't count on more than two hands. The number of firms that might be looking at what's referred to as fine-tuning a model, which would be taking the underlying base model and then actually trying to train it on more specific proprietary data so that it can provide slightly more tailored responses. But otherwise, most people are just using those models off the shelf completely. And so really the value of the legal AI is a question of what's the delta between what you could basically do with ChatGPT or Perplexity or Anthropic directly and what this legal AI solution is delivering. The solutions themselves are getting insanely expensive, especially these horizontal ones, like to an alarming state. Even I'm alarmed, and I'm very bold around investment. And I'm seeing the prices. I'm like, wow, this is not going to be tenable. And if you are a smaller firm or a solo practitioner, like that is just, you're not going to be willing to pay some of those numbers. So I think what we're going to see are things moving in two directions. One is we're starting to see what are referred to now as orchestration platforms. And this is basically the Gen AI version of what we used to call low-code, no-code tools in legal technology. So basically, they're platforms that will allow you to come on and actually design your workflow, design your little AI app. And you can configure that. You can choose which underlying model to use. You can write the prompts that you want the system to operate on, but you can do it and say, well, this is my least due diligence review tool, and it's crafted and tailored specifically to how maybe I specifically, or my law firm at least, prefers DD to be done, what issues we think are key, what the output should look like, et cetera. So we're seeing these orchestration platforms starting to come up, which let you do things in a more tailored way. So you don't have to buy that, one size fits all tool. Or of course, we're seeing all those very, very specific vertical tools that are really targeting niche aspects of what lawyers do. So they're very practice specific. They may even be workflow specific. And the challenge now is there's so many of them is if you want to adopt something and you haven't yet gotten there, you have to decide what the strategy is going to be. And there's no perfect way to do it. I think ultimately the reason why we perceive anyway that so many firms have rushed in to invest, I think is more you're getting on the adoption curve. You're not off the curve yet. You've hopped onto the curve. You may be hanging off the back of the train and trying to see if you can make your way onto the car properly. But you're starting to socialize with your people, what these tools are, how they work, how to use them. The fact that it does require some new skill sets. We don't need all lawyers to become prompt engineers. I personally don't think that's a role, but we do need them to understand what prompting is. And when you've got a tool that uses prompting, how prompting well can improve the outputs of what you're looking for.
I'm going to stop you. I must say that, the idea of having to upskill in terms of becoming, understanding how to use prompts sounds terrifying. But thank you so much. I'm sorry, I
Oh, yes.
didn't mean to cut in, but I'm just going to get Karen to offer to do her part, and then we can come into some questions. Thank you.
Sure. So yes, with 5 minutes to do all of responsible use and deployment, I will speak quickly, but a lot of the
Have a
themes-
couple of extra
Oh,
minutes,
that's
it's fine.
But a lot of the themes have been touched on. I think I can kind of sew them up a little bit, and some of these, there's 2 slides. They have an eye test quality to them, so I'll make them available. So don't worry about that. I think what's really exciting and what we're hearing from everybody is we're moving from an environment where most of the activity was around proofs of concept, innovation. What can these tools do to an environment where how do I use them in my work? So we're moving from the lab to more natural environments, and how does that go, right? And what's interesting is how that goes is very much a function of how the people go, right? As much as how the technology is, right? So it's a function of, how well are the humans kind of not just in the loop, but kind of on the loop, which is what this graphic tries to display. Is humans are involved at every step of this discussion. It's how good are my data? How good is the math that I'm putting on top of the data? And if you put those things together, it's a model. And where I want to focus some of the responsible use conversation is it's because it's this rich mix of what people are doing and what the technology is doing, how well the people are doing, how well the technology is doing, how well they're doing together. It's really, and as lawyers, and I'm a recovering one, it's always about the people, right? It's about how people make smart decisions under stressful circumstances, how they fail to make smart decisions under mundane circumstances, and none of that changes with AI. It just gets inserted in different ways, and it's going to manifest in different ways. Fundamentally, these machines, most of them, the ones we've been talking about, there are different architectures, are ginormous prediction engines. They are predicting next likely outcomes based on all the material they've been trained on, the material you've given it, and the way you've asked the question. So it's really important when you're selecting tools, like they're very good at summarizing, we've talked about. They're less good at predicting human behavior. Actually, I mean, there's a whole science around predictive analytics, but it's kind of wobbly, right? They're very good at mimicking form, which is why we get the false citations. They know what a citation should look like. They know what a Shakespearean sonnet should look like. So they can mimic the form. The content is a little wonky, right? Which is why, and they're very good at persuading us with form that the content is excellent. And so the vigilance that it takes from humans to kind of understand that is really important. What I want to focus on this slide here is at the end of this sort of system, where I think of AI governance or tech governance, more broadly speaking, is where a model has produced an output. When do we turn that output into an outcome, right? And that delta or that air gap between outputs and outcomes is where a lot of the governance needs to be focused. And when we are doing a recommender engine, sort of what vacation should I go on next week? Where should I have dinner for my birthday? That gap can be very narrow because the consequence is very low, right? If there's a mistake in that recommendation, it doesn't much matter. Where I'm doing a medical diagnosis or an underwriting a loan or admitting somebody to college or not to college, that gap needs to be higher. And that's where we need to insert more governance. And that governance needs to address sort of how humans have been trained to work with the machines and also just how good the machines are. So when I talk about transparency, sometimes that's human process transparency. Tell me what you did and what your prompts were. Sometimes that's machine level transparency, which is how did the machine actually process the predictions that we built this response on, right? And then what did we do with that? What was our process in the model output? So it's really important just to distinguish between model outputs and then the sort of the commercial or social outcomes that we are looking for. So we can advance the next one. So when we talk about AI governance in our work, and this is the eye test, and I apologize in advance, we're really talking about 6 steps, really, right? And we've talked about it. It's strategy. What do we want to do with the AI? What problem is it solving? Is this the right tool to use for this right kind of problem or this kind of problem? It's risk management, which is I think becoming an active sport. I think traditionally we think of risk management as kind of a passive enterprise governance sort of tool. This is how do we take risks smartly, right? How do we justify risks that we're taking? It's a completely different front-footed posture for risk management when we start talking about AI. Organizational readiness, I'm going to come back to that. That's where almost all the work is happening right now. I've got the perfect strategy, I've got the perfect tool, I've done the risk management, but if my data are a mess, if my people aren't trained, if my structure isn't up to task, if I don't have the right vendors, I'm getting nowhere with that, right? We put all that in the readiness category, and that's where most of the work really is happening in most organizations. And it's why when Tara's doing her work, the adoption is not super broad because the data still aren't great, right? I've not yet been into an organization, public or private, where data governance is where it needs to be to really leverage these tools well. And then you get into things like principles and processes. Those aren't so hard to find if you go, I mean, Claude will produce your principles fairly well, right? And you can tailor them. That's not so hard. Getting people to understand them is. Processes and tools that you select, that's sort of your ecosystem. And then there's compliance. And the reason I want to walk you through that stack is because as lawyers, there are a large proportion of us who start the conversation with compliance. It's not a bad thing. We're going to need lots of lawyers to do that. But the problem starts at strategy. I mean, that isn't, if you're just focused on compliance, you're going to be missing a large piece of the landscape, and you're going to be missing the interesting bits of the landscape. So how you prosecute cases, how you defend cases, I guarantee the compliance is the tail on the dog, right? It might be the motivating factor to get somebody to invest in a sort of a legal process and training. Like the EU AI Act already requires sort of some level of AI literacy focus. That's a good motivator or sort of forcing function, but it's not where the action is going to be in your fact patterns, and it's not likely where your witnesses or your evidence are going to emerge. They're going to emerge from the other, did we do a good job getting ready? Were our data in order? Were our people trained? Were our organizations structured properly? So for every one of these 6 sort of layers, we look at 5 categories. We look at the people, we look at the data, the technology, the structures, and the ecosystem, right? And the ecosystem includes your partners, your vendors, your customers, right? Your regulators, understanding what that looks like. And those questions have to be answered kind of not necessarily in this sequence, but they have to be answered sort of completely across the stack. And then the other thing that I would just emphasize is that it's not enough just to look at AI when we're talking about responsible use. We've got to look at how AI implicates cybersecurity, right? It is both a sort of an offensive weapon, and it is a defensive weapon. So AI cybersecurity very closely tied. We've already talked a little bit about how it's tied into privacy. The other area that I just want to highlight, certainly climate. There's all sorts of climate implications and public goods questions that we need to think about. Also national security. The fundamental fact of the matter is right now is that to the extent we're going to get global regulation or sort of any kind of global ubiquity in how we're going to approach these tools, it's going to be national security driven. And in the United States, and we can talk about that a little bit more, but in the United States, if you're looking for what is likely to move in terms of legislation at a federal level and what is not, the answer to your question is like, what kind of national security question does that raise or implication does it raise? At the states, it's a little bit different. They're a little more ambitious on sort of social goods and civil society, but again, the conversation's always going to circle back in some way. So understanding how the geopolitical landscape is shifting, as well as the technology landscape is shifting, as well as the green economy fundamentals are shifting, is really important to grasping how governance really needs to go. And this is where leadership are challenged, right? Is that it's not the way organizations tend to be set up. And this is sort of the last point I'll make right here is they tend to be set up to look at these cybersecurity as distinct from digital transformation, or as privacy is distinct from our national security concerns, or climate is a very separate inquiry. And when one of the things that AI is starting to reveal is that that's an incomplete perspective. And you're going to either waste a lot of resources and do a lot of redundant work, or you're going to miss important things if you're not taking a much more comprehensive view of the problem set and the landscape in which the problem's coming up. So a lot of it, tech governance ends up being deeply strategic, which is what brings me back to that original point, which is that to do governance well in this space, you really have to start with strategy and risk management. And we have to resist the tendency, I think, to retreat to sort of any kind of a checkbox. Did they check off all the right boxes? It's not going to answer most of the hard questions that we're going to have to confront. So on that cheerful note.
Yes, very cheerful, and more complicated than I think that any of us was really expecting, possibly.
We're not going to be bored.
Well, no, I like the idea that, we're talking about AI, but seems to me all about checkboxes in one form or other. But you're basically saying that's not how it's going to be properly governed.
No, because it's what the chatbots are doing, right? And
Yeah,
it's
exactly.
right. So for HR, like, the chatbots are pretty good at recalling policies, right? That's fine. Are they as good at sorting resumes? They're okay. There's governance you could put around that. What they're really not great at yet is performance, how doing test and assessment and sort of performance evaluations and how do you do, so one more minute. Okay. So AI, right? And now everybody's talking about agents, right? Which are some of these sort of automated workflows that Tara was starting to talk about. And agents are the thing. We're all going to have to learn how to work with agents. We're not at that yet. We're sort of at what I call the agentish phase. It's not the agentic phase, right? Where it's a lot of hybrid technologies that are still very human scoped, human designed, and human supervised. The reality is that the world we're going to end up in is going to have our analog process. It's going to have our original or sort of OG AI process. It's going to have this agentish, there's always got to be a lot of human hands on it kind of environments. And it is going to have a lot of agentic. And so those of us who are in the governance space have to understand that that is the world we are governing. It's a highly agentic system that is calling on human-based systems to kind of inform it, right? So how do we start to unpack, or how do we start to build governance models around, and governance isn't just controls, it's understanding and disclosure and all the things we've been talking about. But so the landscape is going to get very, very complicated in terms of what is automated, what is human, what is not. If I'm a person being managed by an agent, am I being evaluated in my workplace differently than a human who's not being managed by an agent? So that's where the questions, to my mind, get very interesting. And I'm not sure the EU AI, I don't want to point at Will. I don't know that the EU AI Act sort of is probably supple enough to accommodate some of this, but it's not really built to address the real problems and questions that every organization is going to confront, whether or not they're regulated. Right, like this is.
I'm going to stop you there because I think it's very complicated what you're describing, and let's just see what we come back with. I think, Julie,
Right. Well, this section is going to be a bit tamer by comparison. So ignore relax.
Yes.
So I'm just going to talk through a bit of an internal reflection of what's been happening at Doughty Street.
And you need to use a microphone properly because we can't really hear you.
So yes, an internal reflection of what's been happening on the ground in Doughty Street over the past 12 to 15 months, really, with regard to AI. I've got an interest in AI, and it just so happened that I've been able to run with it and with other barristers and chambers such as Matt and Graham, trying to educate our barristers on the rapid developments of AI, the implications of that, the tools that are out there that our barristers can use, the capabilities of them, the risks, just ultimately to help make sure that, we don't get left behind, and, it is disrupting the legal industry and every other part of life. So it's important that we're on the front foot. So staff and barristers at Doughty Street are using AI to various degrees and various forms. That includes legal research and for efficiency purposes, such as Microsoft Copilot. But, the nature of the barrister's work is that it's decentralized. Barristers are self-employed. So, that is a barrier to the kind of top-down AI deployment seen in large firms, which Tara discussed. Even if we had the pockets, we wouldn't be at liberty to pull together a knowledge bank of all Doughty Street cases to train an AI model into a hive mind. But what we are trying to do is to guide our barristers, educate and provide insights on the tools that are out there and that can have a positive impact. So it was about a year ago, I think, when ChatGPT was really hitting the public consciousness, that I think it became evident to Graham and I that we needed to take the lead internally and establish at least a foundational understanding of these tools. So we provided some in-house training, which has kind of lasted the test of time, where we unpicked the terminology around AI because it is confusing. We discussed the capabilities of large language models and their risks. Because, given how easily accessible these tools are, you just log on and put on a prompt and hey presto, it was imperative at that early stage to pass on some key principles for safe usage, i.e. never put confidential client information into a public chatbot, rule number one. Also, there was the key issue and continues to be the key issues of accuracy and verification. So long before the case that went viral last week, the Borough of Haringey homelessness case, which you may have read about, that poor junior barrister, Graham and I discussed during that training other cases that were in the US where fabricated cases had been generated by AI, presented as fact in courts, and hey presto, we're talking about them to this day. And we realized at that time, a year ago, it would only be, a matter of time until those kind of bloopers appeared here. So we wanted to, sound the alarm bells early for those that were listening. And I think that's the issue. It's trying to get people to listen. And more people are now, because you just can't avoid it. And those instances where, you go to court and you get publicly shamed, as Matt said, they're obviously incredibly embarrassing for the counsel involved, and it casts doubt on the entire profession. Can lawyers be trusted with AI ultimately? And the message we're trying to push home is that barristers must comply with their core professional obligations, as they always have, even with AI in their toolkit. And to assist with that, Chambers have created some internal guidance on the safe use of AI in legal practice. And we're going to put a distilled version of that available on our website. But another message is that, the experimenting piece, familiarizing yourself with these tools is essential. The penny only drops really when you're seeing it for yourself in real time on an actual case and you understand its capabilities. And to help with that, we've organised Chambers-wide trials of AI-powered legal tools. Someone in the questions asked, what tools can we use as lawyers? Well, here at Chambers, we've rolled out trials of Thomson Reuters Co-Counsel Core and Lexis Plus AI. I think, as Tara said, these tools don't come cheap, and in many cases for our barristers, they are cost prohibitive. But the value add is their functionality. You're able to upload and interrogate hundreds of documents, summarize them, build chronologies. Some of the best paid for LLMs out there can replicate that functionality, but you pay the premium for the robust security guardrails that you have. These particular AI tools have anyway. So barristers can safely upload confidential materials without worrying about the model, the underlying model being trained or that data being retained. Another key differentiator using these very expensive tools for our barristers is that they are less likely to hallucinate and make up fake citations, as they use a process called RAG that grounds responses in specific retrieved documents, and they are trained on authoritative databases of legal materials, as opposed to public LLMs, which are generally trained on everything and anything available on the public web. But despite all this, these models aren't perfect. So, one of my roles is just to keep getting feedback, because I'm not necessarily asking barristers to pay a premium and then, their job is done. It's more about the cultural mindset. It's getting people used to what's coming, because things are changing fast and it's going to be unsettling. Some report that these tools are actually slowing them down, as they meticulously check everything. So it's not simple. But we realize that our barristers ultimately will judge how AI can improve their practice and save time or not. But it's clear through other examples that when used well and responsibly, AI can positively augment barristers' work. And that's the key word, it's augment. I don't believe that Doughty Street barristers are going to be replaced by AI in their totality anytime soon. But I think those who use AI and use it well will have more and more distinct advantages. As Matt mentioned, I think he's right in that it probably will be negligent not to use AI in legal practice as more and more, efficiency gains and therefore cost savings to the lay client and the wider justice system at large becomes reality. But at Doughty Street, we will keep banging the drum to say, yes, this is increasingly going to be an inevitable component of modern legal practice, but we will emphasize responsible use and limitations awareness.
Fabulous. Well done, Julie. Thank you so much. That was very, very interesting. So really, let's see what we have by way of questions. There's a lot there to absorb, I have to say. I think it feels very much like the note of caution is where, on a practical level, we will exist, but there's obviously a lot more to explore in terms of governance and possibilities beyond the day-to-day. Shall we start with questions in the room? Is it the orange shirt?
That is Simrat from Landmark Law Solicitors. I'm wondering whether when you instruct from your chambers a barrister assisted with AI, will it cost you less money?
Will it cost us investment?
Less money.
Less money.
Oh, less money.
Because you will do his work quickly.
I see. So you're saying yes. Well, inevitably, we can't bill for time that hasn't been taken. So that would, again, it comes down to professional obligations and being transparent and honest. So yeah, we could be, digging ourselves into oblivion by using AI, but if it's there and the efficiencies are there to be had, then that's the kind of the bottom of the tree that's going to be taken away from a case that, we have to invest into more strategic work or a bigger volume of work to make up the shortfall.
Any more in the room? I'm just going to see if there's somebody else, but no, please go ahead. This over here.
Can I just ask whether there should be some obligation on people who use AI in the legal profession to source that in their footnotes, so that that will go for judges as well as lawyers, because at least that way, whoever's reading that piece of text or submission or whatever can have some idea as to whether or not AI has been relied upon.
Who wants to answer that?
Matt.
Yes, this is my bugbear, unfortunately. So I'll explain the issue and then you can tell me what you think, perhaps. My view has always been you should be open and honest in saying you're using it. It's always been like that. But in April 2025, the judicial guidance was updated. And I'll just read to you what it says about lawyers. All legal representatives are responsible for the material they present before the court or tribunal and have a professional obligation to ensure its accuracy and appropriateness. And this is the key point. Provided AI is used responsibly, there is no requirement for the legal representative to disclose its use. And it says, although this depends on the context. So my view is we should just be open about it and say, yes, we use it. If you instruct me, I definitely use it. And we have on our website, we will have in our data policies how we use it and why. So that's there to be read. But my reading of that guidance is that as long as it's used responsibly and we check the generation, there's not an obligation to disclose that, which I do find slightly problematic, but those are the rules.
I think the challenge with the rule, and I've discussed this within the law firm context, is how do you actually formulate that rule? Because, and again, AI is a form of technology. Quantum's coming. There's going to be new technologies. We use the internet search and things like that to find information. A lot of lawyers copy paste some of that information off of Google and search engines. We don't disclose. We use Microsoft Office or a legal text solution or things like that. So what is it that you're disclosing about AI that makes it different? is the question, right? That gives it rise to that there should be a rule or an obligation to affirmatively say you're using it. And I think the challenge that I've come across is you kind of want to say, well, if you've used it to a really material extent, right? Like where you're extracting and essentially copy pasting large things that have been created by something else, then maybe you should probably have something there. But there's no way to actually define that in a practical way that gives any lawyer a real understanding of when they need to say that. So as an example, at my previous firm, we did say that if it is wholesale AI generated content that you're handing to a client, we gave them a disclaimer and we said, this is the disclaimer that you use. In most cases, that is unlikely to happen. And therefore, we dealt with it up front by notifying all of the clients that the firm would be using AI. And then, of course, from a contextual perspective, on a matter by matter basis, you may decide together to what extent you do use some of those AI outputs, but not necessarily having an express disclaimer.
And just on a housekeeping point, at Doughty Street, we have invited all our barristers to update their privacy notice on their website profiles to say if they use AI in any way as part of their casework.
And do we also, I should know this, I know, are we also invited to include use of other tools that we may have available to us? Because I'm struck by what Tara said, because that's what was in my mind, that this is not the first time that we're using tools to speed up our efficiency.
It's more about the client confidentiality piece where that data is housed, the data centers, etc. So it's more about the protection of the client data as opposed to just a tool that you may be using to check your grammar.
The concern I have with other tools we use, they're searching, go to find information, you can then do something with yourself, whereas AI is very, very different. I mean, that's the difference. Otherwise, we wouldn't be here having conferences on it.
Yeah, but I think there's a lot of things that people in the current use of some of these newer AI tools, I think there's a lot of things that happen that were already happening. For example, you search on a legal database, you search on Google or the search engine, you find other law firms' descriptions of things, and then you kind of synthesize that all together. You're pulling from other sources. As I said, I think it's an open question. At what point does the needle tip to actually professionally you need to be disclosing what you're doing?
Yes, that's one for everyone to take away. Any other questions in the room? No. Are there questions, Julie, that we can pick up from online?
Try. I'm wondering if maybe Graham, you could give a specific example of how you're using any AI tools to good effect, whether it is saving time. And there's quite a long question after that that's going to be probably divided into two parts. So do you want to go ahead with that one and then take the next one between?
Sure, yeah. I mean, I'm experimenting with a lot of different AI tools with mixed results. I find it fascinating, but I can't claim to be generating huge efficiencies so far. I have paid an astronomical amount to be using Co-Counsel Core, and it's liberating to be able to upload large volumes of client data without having to worry about the confidentiality angle. So you can use it like ChatGPT, but you can upload material that you could never upload to ChatGPT, and you have, at least in terms of the way it's marketed, you have I think Matt was saying you have less risk of hallucinations, but not zero risk of hallucinations. But I think the difficulty is that you still have to check the outputs. And also, I mean, I have to say, this is one of the, it's very interesting hearing Tara's experience from the corporate side. I think it's not very good at some of the tasks that we try to give it using the material that we give it. So I think if you're working with large volumes of fairly uniform electronic documents, it's probably quite effective at some of the tasks that it claims to be able to do. But one of the things that it was suggested it could do quite effectively was to take a single PDF that runs potentially to hundreds or thousands of pages, comprises some digital documents, some scanned typed documents, some handwritten documents, and it could assimilate all that material and generate chronologies and summaries and so forth based on that material. And in my experience, I haven't found it to be very effective at that. I've had quite mixed results, and certainly not consistently good enough results that I could ever possibly trust the outcome without going back and checking the source material myself, which at this stage feels like it slightly defeats the object, but I'm kind of enjoying the process, so I'm going to stick with it. But so far it feels to me quite embryonic. Like I think it augments my practice, but whether it's really saving time, I think it remains an open question.
That's certainly been my experience when I tried to use co-counsel, and I always have, various types of documents like that. And I was a little disappointed actually, because I thought it was going to, massively save time, and I almost sort of, chunked my time accordingly. It didn't.
I mean, I think I've considered figuring out ways to work with it, and I think one of the things, but again, this is a time cost, right? You have to take that big PDF, split it into smaller PDFs, run it through an OCR engine in Adobe before you upload it to co-counsel and so forth, and then it works better. But there's so much work involved in that query whether you should be writing your own chronology in the first place.
Which is why, in terms of what Tara was posing, that sort of where does it tip into something that you have to disclose category, it feels to me that we're quite far off that, because we're still using it for fairly mundane tasks. I don't know what Matt thinks about this, but you're using it for fairly mundane tasks which could be repetitive and are very time efficient. Whereas, in terms of what I said at the beginning, which is what can be done by way of prediction of outcomes, say, if you want to, you go before a certain judge and you want to know what the likely statistics are in front of that judge, and well, how should I present my argument there in order to be successful, because that's what he's done in the past, that sort of thing. Now, I can see that takes it to another level. And I don't know to what extent people can use it to do things like that yet, but is that what, is that something that feels like we're taking it outside of the mundane? For me, that's what it would feel like if it looked like that.
Yeah, I mean, I think there's I think we're barely scratching the surface. And the simple fact is, technologically, there's the ways a lot of some of the applications are built. If they haven't done, for example, RAG properly, it can't understand that 1,000-page document. It can only ingest smaller versions of that. So it's hypothetically, the model itself could handle it, but the application sitting on top of it can't, for example, which is challenging. So I think the applications themselves don't always help.
Yeah.
Is there another question online?
Okay, so in terms of judicial review and disability discrimination, e.g. in automated decision-making causing detriment to disabled clients, 1, if the use of AI can be justified in relation to plunging budgets, is the use potentially defensible as reasonable as a result? 2, in the housing context, are we challenging the decision to use it, the action of the AI as an agent of the local authority, etc.? In effect, which is the decision under challenge and who is the target?
It's a housing question. Does that mean it's me?
You can deal with the housing.
Sorry, could I have the questions one at a time? But I'll just give a brief view.
So in terms of judicial review and disability discrimination,
yes,
in automated decision-making causing detriment to disabled clients, in the housing context, this is the actual question, in the housing context, are we challenging the decision to use it, the action of the AI as an agent of the local authority, etc.? In effect, which is the decision under challenge and who is the target?
Okay, so the answer to that is maybe, and that there are some significant points there which are highly fact sensitive. So with disability discrimination, if you're going to bring that as a standalone claim, that's different from, for example, if you want to raise a breach of the public sector equality duty. And there's several things to think about with that. Every decision that's made in the housing context is quite different. So the one I envisage when, and I'm sorry to keep referring to my blog, I know it's selfless promotion, but the one I discussed there was, for example, a homelessness decision. So that process is you apply to the local authority as homeless and they consider your application, they send back a decision, and then you can make representations. Now, I have several cases at the moment where the difficulty is the representations are made by the homelessness individual using ChatGPT, and then there's a response from the local authority, and the question mark is whether or not they used AI to respond to that. And I'm starting to get concerned that you get the situation where the applicant is using ChatGPT, the response is being used by ChatGPT, and then you have to wonder who's actually making the decisions. Now, the problem with ChatGPT, and it's something that actually the senior judiciary have mentioned several times, is this. There are all these problems. So you have, with all the AI, inherent biases and discrimination, when we've seen it in some of the decisions and images that it creates. But at the same time, and there are several cases now for the Employment Tribunal, ChatGPT is a great tool for vulnerable people who have the ability to make representations that they would have found difficult otherwise. So it's really balancing up whether it's something that causes more issues with disability discrimination, or in fact, it's actually a reasonable adjustment and assists with what's happening. And in my view, that's highly fact sensitive about what's going on, because I am concerned about it being adopted. But what I'm more concerned about is the disclosure of exactly how far it's being used. And I think we're going to see in housing and immigration very soon some decisions on that and exactly where that balance does lie. So sorry, that's a long way of getting to the answer of it may be justified, but it really depends on the circumstances, as justification does. And always remember, it's for the person who it's alleged is discriminated to justify. And so we'll have to see how that proceeds.
I think, if I may, I think I'm going to close with a question on governance for will, simply because I thought that was quite complex, and maybe that's something that we could try. So you obviously spoke about the EU AI Act and the various the pyramid and the risk models, and also the transparency model. Now, listening to what we've listened to today, and the idea of transparency seems to have been a key feature of the way a legal practitioner might need to approach the way that they're using AI or any kind of assistance of that kind. Just wondering whether you have experience, not simply just from the EU, but from jurisdictions more broadly in the legal practice arena of differences. And I understand there are some jurisdictions that will not permit any use of AI at all. Is that right? And then, of course, we're a little bit more permissive here. So whether there's any learning or thinking that we could be helpful.
I think certainly transparency is a key theme. Sorry, I'm really struggling with this microphone. A key theme for lawyers using AI internationally. I think where a lot of what I've seen in practice, and this is maybe more in the world of internal policy than in terms of guidelines or official guidance from, say, regulators, is that the sensible place to draw a line is where you, as a law firm or as a barrister, are no longer purporting to take responsibility for what is there. Because if you're not saying, I've used AI, you really are just taking responsibility. You're saying, this is from me. And so if there's a mistake in there, it is 100% on you. If you are using AI and you're not editing something, then realistically, you should be saying, this is generated by AI. It wasn't made by me. And this is why, going back to the question we had earlier, about whether you should be saying in legal submissions that it's been generated by AI, I would be saying, at this stage at least, no, because no submission solely generated by AI should ever get anywhere close to a court. It should be something that's at a very early stage in, say, your research process. It shouldn't be, please draft my pleading, which the tools are not equipped to do at this point.
So you're happy with the permissive use of AI, but as long as but transparency and clarity and over-reliance and responsibility seem to be perhaps touchstones that we could look at.
I think, I mean, when we were chatting about this in advance with Karen, you made the point that it's relatively easy to police a chatbot when it's producing one mistake in every 5 outputs. But when you get to the point that it's only producing one mistake in every 50 outputs or every 100 or every 1,000, the sort of inherent integrity that you're talking about, Will, in how you present that material to an external audience, the duty doesn't change, but the motivations, I think, change in the sense that the people are much more willing to run the risk when the chance of there being an error there starts to decline.
Yeah, I think on some of these things, there's a risk of holding AI to a higher standard than we hold humans. Because if it was a question, I mean, if people I worked with produced 1 error in every 1,000 outputs, I would be pretty thrilled, to be honest. So I don't know.
But I think that's one of the challenges with this move towards agentifying certain workflows, is it's shining a very bright light on our very deficient human processes.
Yeah.
right? And as automating a bad process is just automating a bad process, right? And so I think the biggest challenge most organizations are having is figuring out which of their existing processes are worth investing in the automation around and which of those processes need to be really rethought, right? And that's where some of the gains are going to come, is when we really start rethinking how we do things, not just doing what we do faster.
I mean, most of the good use cases I've seen for AI in law are things that you probably would never have done with a human. So the best one I think we've done in-house is we had a case with, I think it was hundreds of witness statements, and we were trying to assess, their coherence. And we, our technology team managed to, I can't really go into details of how they did it, but to assess the internal coherence of all these witness statements. And it produced this amazing table saying, oh, well, paragraph X of this witness statement is incoherent with paragraph Y of that witness statement. And, you're probably never going to tell a junior to go and compare every sentence in this witness statement to every sentence in these 99 witness statements. But that's a task that AI can do, and it can be told to go and do that. So that's where the real power of it comes in, for me at least.
Great. Okay, look, I think it's probably time for us to bring this to a close. So I just want to say thank you very much, obviously, to our clearly expert and wonderful panel for some very complicated but interesting and thought-provoking points about what's coming for us for the future. I hope that people have been able to take away a good few learning points from what they've heard today, and there's obviously lots to build on. Please do take a look at our website and see what we've got on our AI team and so on there. But I think otherwise, I'm going to say thank you very much. Let's just thank our panel. And we'll bring this to a close. And for those of you who are in the room, we have some nibbles and drinks as well, so we can continue our conversations over those. But for those of you who've joined us online, thank you very, very much indeed for being with us, and good night. Thank you.